Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Libertarian Party of Virginia versus Judd, 718F3D308, Court of Appeals, 4th Circuit, 2013. Friends, today we're going to talk about the staple of this podcast, ballot access, and part of that, gathering petitions. This case inspires us. You will see why. Stay to the end. One thing I like to see right away is the Thomas Jefferson Center for the Protection of Freedom of Expression filed an amicus brief. Way to go. We want as much support as we can get in these cases. I don't know about you, but when I have my civil trial in appeals courts, I would love to have people filing amicus briefs on my behalf. So let's read from the record what happened in this case. It says, quote, in the spring of 2012, the Libertarian Party of Virginia, the LPVA, began to circulate petitions throughout the Commonwealth in hope of collecting enough signatures to place its national candidate for president of the United States on the ballot for the November general election. To achieve ballot access for its candidate, the LPVA was required to obtain the signatures of 10,000 qualified Virginia voters, with each of the Commonwealth's 11 congressional districts contributing at least 400 signatures toward the total. End quote. 10,000 sounds like a lot. Also, they mention how it has to be some of each district. I do remember another case we discussed on this podcast which mandated that it can't just be any individuals from the state, but it had to be a certain number from each area. So that makes it harder yet. Also it states, quote, in accordance with Virginia law, signatures on nominating petitions must be witnessed by either the candidate personally or by a person who is a resident of the Commonwealth and who is not a minor or a felon whose voting rights have not been restored, the witness residency requirement or the requirement. On May 14, 2012, the LPVA, joined by Darrell Bonner, a Pennsylvania libertarian and professional petition circulator, collectively the plaintiffs, filed the underlying action in the Eastern District of Virginia seeking injunctive and declaratory relief pursuant to 42 U.S.C. Statute 1983. The plaintiff's verified complaint alleges that the witness residency requirement impermissibly burdens their rights to free speech and free association in the First Amendment as made applicable to the Commonwealth by the 14th Amendment. End quote. Again, we're seeing our friends invoke the First and 14th Amendment, a theme that's in these vast majority of the trials. These amendments rock, so we love to see them invoked. What do you think about that strategy of invoking those amendments, friends? It goes on to say the Libertarian Party, in addition to using that Darrell Bonner gentleman, use part of their constituency, part of their membership to circulate petitions, and they don't pay them. So let me ask you this. For those of you who have circulated petitions, do you prefer getting paid professionals or do you prefer unpaid people? When I gathered my signatures, it was in the hundreds that I had to gather, so I did it myself. I didn't even think of the possibility that there were people to pay for such things. So what do you think is better? It says here, Mr. Bonner believed having to have people who were not professional, who are not doing it for pay, made it more difficult to gather signatures. In the footnotes, it mentioned he said this because oftentimes they would get into discussions with the people who wanted to sign. And sometimes the discussions were counterproductive, so the people didn't want to sign. That's a good case for needing the professional people. People who are involved in third parties in politics have passions. And although they might want to avoid sharing those passions when they confront voters, it can be very difficult. People like Bonner are trained to do that, so they might have more ability to withhold such things. It mentions in this state, the requirement is an outsider can come in, like Bonner, as long as they have a resident of Virginia with them. And that's why Bonner has to deal with making the process more difficult by having the resident with him. If he could just do it himself, it sounds like he would be more efficient. So the court dealt with this issue. They did a little discussion on the nature of standing, but most of the case pertained to the issue of this requirement. As they stated, quote, indubitably, restrictions on this sort of core political speech can affect the ultimate goal of ballot access. Deducing that the Colorado statute criminalizing the payment of petition circulators makes it less likely that proponents of an initiative measure will garner the number of signatures necessary to place the matter on the ballot. End quote. I love the word indubitably. It's a word that is used very infrequently. When I was a kid, we had this game on our computer. It was one of the first CD-ROM games out there. It was called The Manhole. And there was this character named Abernathy who said, indubitably, my brother and I found it amusing. So I love the fact they're using that. I don't like the fact that Colorado would actually make it illegal to pay people to gather petitions. That sucks. That's a bad law. The court makes an argument for our case. It mentions that this law not only restricts ballot access, but in an indirect way it can restrict freedom of expression in a deeper sense, because ballot access can be used as a way to communicate the message of the party and the candidates. So you're not only dealing with getting on the ballot and using the election to express yourself, but the very act of petitioning is a way to express yourself. The Board of Elections here was trying to argue the Libertarian Party was able to do this in the past, successfully get on the ballot, so the 10,000 signatures is not an issue. But the court did not buy it. Sometimes you read these cases and you think the courts are not going to ever favor our side, but sometimes they do. Like here, they're seeing validity into this. It talks about Bonner. It says he is a CEO of the company Central Petition Management, which he founded. Friends, that sounds like a great business. That sounds like an awesome, inspiring life mission. What a great deal. I trust Bonner is fulfilled in that calling. Let's read what he says. It says, quote, Bonner considers his work an important means of expressing his belief that third-party candidates play a significant role in the political system and should be allowed a place on the ballots. End quote. Beauty, inspiration, awesomeness. What other types of businesses have you encountered in your ballot access or other third-party endeavors that serve third parties and specialize in third parties? I love to find out. One issue that happened in this trial was, unfortunately, Bonner got a knee injury, so it made it more difficult for him to petition in this election. But the court said, although that may have caused him less likely to have an issue with this law because he was less able to participate, this law still is going to be on the books and it still needs to be dealt with. Plus, in his case, because the knee injury could get better, he's going to likely face that himself in the future. So they do say Mr. Bonner has what legal people call an injury, which is something you can sue for. This case was trying to argue that he didn't have any legitimate injury. Not injury in the sense of the knee, but injury in the sense of the legal thing. And indeed, they ruled he did have a good reason. A legal injury. The board here cites reasons for why they believe it's necessary to have people in Virginia handling the petitioners. They center around the fact it is, in their view, necessary to have residents do this because if they need to scrutinize the signatures or have legal proceedings, they can call them easier. And on the surface, that may sound like a hard argument to get over. But the Libertarian Party argues they could have a law or a procedure which requires the non-residents to sign a document stating they will come back and will be held accountable shall the need arise in legal proceedings and other hearings. The court cites another case called Savage that did essentially that. They required people who didn't live in the area to come back if they were going to submit ballot access petitions. The court ultimately says here that this argument by the Board of Elections isn't very good because there are other ways to make sure people are able to testify if they're out of state. So ultimately, what's the decision? It says, quote, having fallen short of adducing the quantum of proof necessary to place into issue the relative effectiveness of the plaintiff's proposed alternative to the patently burdensome witness residency requirement, the board cannot prevail. Given the facts as developed below and viewed in the proper light, we have scant choice but to conclude, as the district court did, that the requirement fails strict scrutiny and is unconstitutional. Pursuant to the foregoing, the judgment of the district court is affirmed. End quote. The Libertarian Party conquers. You did a good job, my Libertarian Party friends. I salute you. That Bonner individual is doing a good job in his calling. We love to see callings like that. So all of these friends, the Libertarian Party of Virginia and Mr. Bonner, are doing a good thing here. And we love to see this victory. We can take this. We can celebrate this. We can use this for inspiration going forward. When we run across things that don't go our way, when we see cases we don't like, when we have depression, we can think about this case that the Libertarian Party of Virginia won. They used good arguments. They had a good witness. Unfortunately, the court was sympathetic. So way to go, Libertarian Party of Virginia. Long live third parties. Goodbye.